It's a very interesting topic. I think WhatsApp and Twitter is something we all use it on our daily basis, or I would say probably every 10 minutes we access maybe one of the two. Uh, you know, doing some justice to my profession, I should start with some caveats here. While we are trying to debate on Twitter and WhatsApp and etc., we are trying to share our experiences. We don't want to venture into taking a position either this way or that way, because some of the topics are still in the midst of possible solution, either in the legal field or possibly with a discussion between the companies and the government. But the whole sole objective for us is to see how some of the events which has taken place from February this year till now, specifically once the intermediary rules came into picture, some of the expectations which was quite vociferously conveyed, by the government, and I would say very strong resistance also probably being given by the corporates. And this is one of the interesting case where it's like who's going to blink the first. I should highlight few things which I think I had touched upon with my fellow panel members in our internal call earlier. Is that some of the things I feel has started way back with the with the BlackBerry as a phone, where their server was expected to be kept in India along with the data. And I think that was the first time I think I saw a little bit of friction or to and fro happening from a corporate versus the government on this topic. And since then, it is increasingly, I think, a turf war probably is going on as to how the digital platform, who controls it, who has control over the data, who's the intermediary, and whether if you lose the status of intermediary, then what happens? And we have seen few examples, probably somewhere around May, when for a period, probably Twitter or WhatsApp, they lost their status of intermediary. So it was going to be very insightful, I guess, and I'm just trying to highlight that again, that some of our observations, while we are talking about certain entities, we are not necessarily reflecting our views on those. So it's just that WhatsApp and Twitter is something which is very common now to be talked about. See, much has been written about IT rules and the way social media intermediaries operate in India. There are Indian platform also like KOO, KOO, and some of them claim that they have fully complied with some rules. There were some companies were in the process of complying, and some could probably raise an objection saying that they need some more changes or they need some more time. Now, given this context, what should have been the government's reaction? Whether government should go to the extent of banning certain or barred some companies from doing business in India because of non-compliance. Classic example is not appointing a compliance officer. Whether that itself means that we should not allow that company to operate in India. I will request my panel colleagues, Dr. Pavan, Duggal, to probably throw some light on this point as to whether government should be so harsh upfront, or we should give some more time and then probably take the eventual action of for banning the entity in India.
Well, thanks, Bharat. The fact remains is that it's not really up to the government. the law has made a stupendous change one way or the other. And the law go back to the year 2008 when the Information Technology Amendment Act 2008 was passed. That's for the first time the Indian ecosystem came to know about a new concept, that of an intermediary, the way it was very exhaustively defined under Section 21W of the IT Act. So when you look at the term intermediary under 21W, it's very broad. Any entity who on behalf of another person receives, stores, or transmits any particular electronic record or provides any service with respect to that record becomes an intermediary. So it's not just only the Twitters and the Airtels of the world who become intermediaries, it's just about any company in the country who is basically using the electronic ecosystem and dealing with third-party data becomes an intermediary. And way back, we had Section 85 of the IT Act, which said that, look, in case if a contravention is committed by a company as an intermediary, then the top management is going to be liable for the same. Now, already under Section 79(3), it's been categorically said that if the intermediaries really want to get the exemption from legal liability in a statutory manner, then they must not really conspire or abet in the commission of any specific offense. And they have to exercise due diligence while they discharge their obligations. So when the IT Rules 2021 came across without any advance notice, they only built up upon these very legislative foundations that were provided by the 2008 law. The only fundamental change was that for the first time, Rule 7 of the IT Rules 2021 categorically said that if you are an intermediary and you do not comply with the IT Rules 2021, be prepared for two kinds of legal consequences. Number one, your statutory exemption from legal liability is automatically evaporated and snatched away from you by operation of law, not by an act of government. And number two, your top management is liable to be punished for various offenses under the Information Technology Act 2000 and the Indian Penal Code. So what the government has only done is going ahead and reiterating in actual practice what's been stipulated under Section 7985 of the IT Act, read with Rule 7 of the IT Rules 2021. So till now, we haven't really seen much kind of a strong action by the government. Yes, the Twitter example was more a kind of a test case. Because Twitter was on a confrontational mode with the government, the moment those 90 days periods expired on 26th of May 2021, the statutory immunity of Twitter as an intermediary automatically got revoked thanks to Rule 7 of the IT rules. And that being so, it opened up a barrage of criminal actions against Twitter. 4 different FIRs filed in 4 different states. And now for each of the FIRs, Twitter has to go ahead and answer the various criminal charges. So it's only one single kind of a signal that the government was seeking to give to everybody that you better be compliant. Otherwise, your neck is in our hands. We can go ahead and take any action against you. And mind you, there's no limitation. The government can even wake after 7 years and take action against you if you have not complied with the IT rules. So I believe the government needs to take a more judicious, holistic approach. We do not really need to scare away all intermediaries, nor do we need to tell them, guys, you stop your business and start doing compliance as a full-time business. No, that's not the job of intermediaries. The job of intermediaries is to deal with various aspects of third-party data. And that being so, there are various compliances that can be done. But in case if these compliances are not done, the skies should not fall. However, the Twitter case has told us that, look, just about any intermediary is going to be potentially exposed. I don't think the government of the land of the day would really want to take any coercive action against all intermediaries, but I do not rule out any specific action against a test case, primarily to give a kind of a signal message to the ecosystem that you better well be compliant with the legal frameworks. Otherwise, there's going to be potential challenge waiting on. And my practical experience tells me, given the kind of work that I do, that almost 9 out of 10 intermediaries in India are non-compliant. And intermediaries really constitute roughly 96% of all companies that are registered in the country. So in a scenario like this, you are suddenly finding a very distinctive challenge for the government. And I don't expect the government to go whole hog against all intermediaries, but selected cases can't be ruled out. Hence, the better mantra will be, let's focus on due diligence. Let's focus on getting our documentations in place, because it's something like, all these companies are going out in rain. It's raining cats and dogs. What these rules and the IT Act is telling them, sir, please get a good raincoat, get a good umbrella before you step out on rain. And these raincoat and the umbrellas are these documentations which are made mandatory by virtue of exercise of due diligence under the IT Act. So very interesting scenario. But ultimately, I'm not a soothsayer, so I can't really predict what the government could or should or not be doing. However, I think corporates now need to definitely add under their distinctive kitty of headaches, one big headache, which is potential exposure to legal liability as an intermediary. And for that, it will be much more beneficial for all stakeholders, specifically corporates and intermediaries, to come within the safe harbor comfort of the statutory exemption from legal liability under Section 79 of the IT Act.
Okay, thank you, Dr. Duggal. Abhishek, you want to share your views on this topic?
Sure. Thank you so much. Thank you, Legal Era, for inviting me to speak. And this is an amazing panel with a very interesting and hot set of issues that are being debated. Specifically to your query, my point is that Dr. Duggal highlighted what exactly the requirements of the law are. What does the IT Act speak of? What do the rules provide for? These rules, as everyone knows, have superseded the intermediary liability rules of 2011. There has been a fair amount of and a drastic change brought about in these rules because we have moved as a society, as users of the internet, as people, at the amount of data that is being consumed on the internet and via these intermediaries. So, and of course, technology has developed. So the basic, I think, position that intermediaries are to be getting the safe harbor protection of the law, because all that they provide for is the pipe. We've moved on from that particular concept. Today, intermediaries are playing a bigger role than just providing the pipe. It is to address those situations, and also because government doesn't want the courts to be burdened with litigation day in and day out. They've provided for an mechanism of grievance redressal within the entities themselves. Now, to come to the specific way that you voiced, should the violation or non-observance of these compliance requirements raise the bar to such an extent that it results in the exit of such companies from India? I don't think it should go to that extent, certainly not in the first instance of violation. The first instance of violation is where you tend to lose your intermediary status and you're open to then liability or potential liability for acts of the third parties. It nevertheless will have to be demonstrated, and such intermediaries perhaps would be able to demonstrate that even though they don't have their Suraksha Kavach of them being intermediaries, nevertheless, they will be able to demonstrate that it is not them who have committed the offensive act, but a third party who has done that, and make a disclosure with regard to that as per the requirements of law, or provide traceability as per the requirements of law. I don't think that it was ever envisaged in the rules, and if it has been interpreted in a manner so as to amount to an egregious sort of a situation where people are thrown out of the country, I don't think that is the intent of the law. I don't think that's the intent of the rules. I think it's just a question of whether or not you comply. If you comply, you get the protection of the act. If you do not comply, then that protection goes away, and the presumption in your favor then evaporates, and then you'll have to go through the process like anyone else.
Okay, thank you, Abhishek. I think you touched upon the traceability, and if the protection goes away. If I recollect right, somewhere in May when the protection was removed, I think there was a complaint filed against Twitter's. I think it was in UP, if I'm not wrong. And I have not followed that case, but it's interesting to see how quickly the action was taken when the protection was withdrawn. Now, if we come to the compliance part and the issue about whether Twitter, of course, has raised that there is a threat to freedom of speech. And also, WhatsApp has made its objections to the rules in public as well. And if I'm not wrong, on the issue of traceability, I think there was a case filed in with Delhi High Court. Now, while they are simultaneously trying to comply with the rules, I think the question also arises, as a user for me, the intermediaries are claiming that whatever you communicate is encrypted. It's an encrypted data. Whereas, so I have that comfort that, okay, whatever I'm going to write is not going to be disclosed to anybody as long as the content is concerned, as far as the content is concerned. But if the rules say that intermediaries will have to give the access of data source or who has initiated this message, then that will be disclosed or should be disclosed. Of course, it needs to be a right law enforcement agencies. Vaishali, I would come to you to probably ask this question: to what extent this is justified? Will it end up compromising the me as a user, for example, as to what content I have written on the message?
Thank you, Bharat, and thank you, Legal Era, for giving me this opportunity. It's also a pleasure to be part of such an august panel. Let me come to the question directly, but I still want to touch upon what Abhishek just put in perspective relating to intermediaries having a very innocent posture for the last 21 years of being a pipe for content. I mean, they've always maintained this, that, we have nothing to do with the data, and why are you blaming us? And, we're just intermediaries in the way you need to understand the term. However, we all know that for the past 21 years, actually, they did enjoy the safe harbor kavach, as again Abhishek said. However, they did not do anything to ensure that the kavach remains on them, and we had to do something as a government, and I would say even as for this protection of citizens, because what eventually has happened due to the intermediaries way in which content is handled is that now we all know that they have a capability of either promoting content or burying content or even manipulating content to a large extent. And that is why the government had to step in with a legislation which seems to be very harsh on the face of it. However, it all, of course, will boil down to implementation and technology. And I'll come to the technology part a little later, though I'm definitely not an expert on that. But if both then are read together properly, then these intermediary guidelines, which now we are all focusing on, which were notified in February, would be effectively implemented to ensure the aim for which they have been notified. And I think the two aims were, the two goals of these notifications were better regulation of the intermediary giants, who all this while actually almost had created pressure so that there is no legislation that brings them to book. Even as a practicing lawyer, I know how many of cases end up in a dead trail because there is no data coming in from intermediaries. And so when we are talking of citizens' rights and citizens' protections, this in itself is a sort of a protection that they also get their cases that are filed see the light of the day, which they cannot because data is not available. So I think intermediaries sort of invited this legislation, if I can say that. Now, coming to this question of the traceability, attribution, and encryption, there is one provision which directly says in the intermediary guidelines and the rules notified in February 21, it says that the intermediary has to, based of course on a court order, so it's not just on the mere asking, based on a judicial order or an order by the competent authority issued under Section 69 of the Information Technology Act, the details of the originator have to be disclosed. Now, once this got notified, WhatsApp immediately went to the Delhi High Court seeking relief, saying that, from what I know, the 3 grounds which have been taken are that this is ultra vires the Information Technology Act itself. These provisions, this particular provision is violative of Article 19, which is freedom of speech and expression of the Indian Constitution, and Article 14, which is the right to life, and of course now right to privacy, which is separate, but we'll also include that for the sake of discussion. I think what perhaps has been overlooked, or what the government of India stand is that agreeing that Article 19 guarantees the freedom of speech and expression, Article 19(2) talks of reasonable restrictions. So when is this information asked for from the intermediary is when it comes under the 4 corners of reasonable restriction. So the guidelines in itself say that such information of attribution or the originator of the message is asked for only when there is enough evidence to show that this information is required to look into an offense which is regarding to integrity and sovereignty of the state, or it is relating to the safety of the state, or public law and order situation or public order. In addition, it talks about child sexual material which could be available on the net, rape, or sexual exploitation. So they've carved out a specific criteria in which the intermediary is asked to disclose the details. There is another safeguard in the intermediary guidelines itself, which says that such orders are to be passed only when other less intrusive measures have been exhausted. So this is not the first order we are asking. Once you look at other measures for looking into evidence as to who must have originated that message or who must have uploaded that content, if other measures prove to be ineffective and there is a dead end and you can't go anywhere looking for evidence, at that time, then such intermediary should be compelled to disclose the origin of the message which has been circulated. Now, this on paper is a perfect argument because this is what has also historically happened. So if you look at how Wiretapping Act was or the Telegraph Act was, these were the exact safeguards. So there's nothing new that has come in, and we have historically followed what we need to do when it comes to the larger public good. And the classic tussle will always remain: the right to information versus the right to privacy. And then the right to privacy will always take a backseat because the right to information is for the larger good and it is for the public good. So once you get into that argument, these guidelines are not unconstitutional at all. The problem here is, and as I said, I'm not the right person to express an opinion on it. Perhaps a technically qualified person should be able to talk about this. Once you ask for, so it is said that encryption and traceability technologically don't go hand in hand. The moment you ask for traceability, the end-to-end encryption gets jeopardized. And that is where the problem area is, or that is where the tussle is. So now the question is, should the guidelines be changed, or should the stronger legislation making the intermediary liable change, or should there be an investment in a better technology? Now, I don't have an answer to that, but that is a classic argument being given by cybersecurity experts, which say that the moment you ask for traceability, the end-to-end encryption is not guaranteed, and that makes you and me as citizens vulnerable, because an end-to-end encryption which otherwise guaranteed privacy, it also guaranteed that no third party would have access to that content, that gets jeopardized. And I think the more problem area is the government is going to get access to that data. So then who will say guard the guard? Because now there is data harvesting done by the government itself under the garb of traceability. And that is what is a real cause of concern. Thanks, Bharat.
Okay, thank you, Vaishali. Dr. Duggal, I would like to probably extend this a little bit. So there is a issue of traceability, but there are some other elements also. For example, right to remove certain harsh content, take down some offensive, or morphed or impersonated content, which is of course justified. Social media verification, some filtering. What's your view on this? This is like more and more regulating as to what goes in, what stays there, and what kind of messaging can be accessed by the wider population.
I think the broader message is very clear, Bharat. It is that ultimately the law does not require certain kind of a content to be up there. And well, that's so because that's the law of the land. Whether you look at the IT Act, whether you look at other laws, that's what the intent is. So this entire issue came up before the Delhi High Court in the landmark judgment of X versus Union of India, where I was amicus curiae assisting the High Court. And the High Court examined this entire issue in the context of a petition of a girl who was a law student whose normal photographs had been taken and morphed artificially on images of nude models and put up on pornographic websites under her name. And much that she was asking the service providers to remove them, they were not getting removed. Consequently, the writ petition had come to the Delhi High Court. So herein, the Delhi High Court not just upheld the constitutional validity of the rules vis-a-vis the removal of this kind of content, and actually even upheld the responsibility of the intermediaries to remove such content which is sexual or obscene in nature within 24 hours. But for the remaining kind of a content, the court actually agreed to the time frame of 15 days removal as was given under the IT rules 2021. So I think what's currently being said in the IT rules is only a logical extension of what we are normally thinking. Unfortunately, almost all of us, when we are using the internet, forget about two intrinsic characteristics of the internet when we use the same. We forget that internet as a paradigm never sleeps. Internet as a phenomenon never forgets. And once anything is put out online, whether good, bad, or worse, it's going to be there for a long, long period of time. And with today a barrage of fake news that's happening all around us, it's very difficult to sift between what's real, what's correct versus what's not so correct. On top of it, complicating this entire scenario is a new rampant revolution that I'm seeing in India. I call it the Great Indian Vomiting Revolution. Indians are vomiting all kinds of information on the internet, whether it's personal, professional, social, or otherwise. So in a scenario like this, when people are not very careful, at a time when the country is itself having a unique historical vacuum in terms of policy, in as much as we don't have a dedicated law on privacy, nor a dedicated law on data protection, nor a law on cybersecurity. In that kind of a policy vacuum ecosystem, these IT rules have sought to come in and provide effective solace and effective remedies to affected persons in this context so that they can ask for removal of this kind of content. Of course, that's also not push button. You will have to go through the grievance mechanism, redressal mechanism of the concerned intermediary. You will have to file it with the concerned grievance officer. If the content is of sexual nature or obscene or artificially morphed pictures, then 24 hours time frame for removal. Otherwise, normal 15 days. I think even this 15 days time frame is a very long period of time. Why? Because if you are being defamed online, then you are continuing to be defamed on a 24/7 basis. So as I feel that as time passes by, maybe this 15-day time frame may be substantially also reduced in the coming times. But as of now, I think all stakeholders, whether it's intermediaries, whether it's data stakeholders, they'll have to realize that this is what they will have to go forward. No push button situations. And even after this grievance redressal mechanism, there are very high chances that these intermediaries may not comply. As we have begun to start seeing in a number of cases, intermediaries are not complying. So we have again no choices but to again file criminal actions against intermediaries and the top managements for having failed to go ahead and address the said issues within the stipulated statutory times. So I think it's only a case of an evolving legal jurisprudence. As time passes by, we should see more advancements happening in this regard. Thanks.
Thank you, Dr. Duggal. And, um, as you rightly said, I mean, 15 days in some of the content is certainly a long period of time. And what we are observing also is that if you put something on Twitter and then you tell Twitter to remove it, but by the time many users have shifted that to some other platform, and then it goes, so it's a multiplier effect. And if some defamatory statement is written against someone, then he keeps getting maligned on multiple platforms. So it's like you need to go across the spectrum and say, okay, this content needs to be removed. But and this is where probably I would bring in the issue of the intermediary rules, and we will bring Nirupam on here. When the intermediary rules were announced, if you look at the reaction which came in the media, it was as if we are trying to control the freedom. And of course, the rules are framed in a way where there are compliance aspects are identified. There are specific regulations are there in part 1, 2, 3. But, with so many platforms being now operated in India, whether it's WhatsApp, you have Signal, you have Telegram, Facebook, Instagram, Twitter, blah, blah, blah. I mean, KOO, which is the other one, there was a hike. To what extent and how long that one can control, even if there is a rule? Because as you can see, the digital space is expanding like crazy. There are multiple channels and options are coming up. And controlling the entire spectrum end to end could become a big challenge. And second element is that by bringing these rules, are we trying to slow down the business in the digital space? Is it going to have an impact on the digital landscape in future? Nirupam, some thoughts from you?
Sure, thank you, Bharat. And I think Duggal Saab has kind of given a very good introduction, kind of laid the entire structure of this rules as well as the ecosystem around it. And so let me continue from there. And I will start with two more philosophical statements. The first is with great power comes great responsibility. So we all know social media has turned up to be a great power. It is a power for social change. It's also power for social destruction, depending on how one is using it. And same way it applies to the OTT platforms or the publishers of online content, whether it's news or whether it's curated online content. Today, especially due to COVID, when people are not really going out, our entire media consumption has got limited to OTT platforms, one way or the other. The second point is more towards the physical reality, and some of the panelists also mentioned this. So when you see something, you cannot unsee it, so you have seen it, and this becomes a real I think my network is slightly becoming unstable. Let me know if you can still hear me.
We can hear you.
Okay, wonderful. So this is one thing which is very, very critical, and again this goes to sexual offenses, which goes to content which is threatening the integrity and sovereignty of the country, friendly nations and all those things, relations with those. So this is an important factor. Once this has gone out, it's very, very difficult to then control it. And again, you prefaced it in your question itself. There are so many social medias, it can transfer from one social media platform to another social media platform. And in some ways, when it started, it was thought of a revolution, because now everybody is a publisher. But later on, as we see, and Vaishali very rightly pointed out, intermediaries are no longer intermediaries in the pure sense of the word, which as defined in the IT Act. And they are now curated, in fact, and that's where the rules use word curated everywhere. So they are now curators actually, and they using artificial intelligence, big data, and algorithms. They are not just intermediaries; they are actually content providers. They tell you which content to see, which content not to see, and also in terms of the advertising part, I think, which was clarified earlier in the court judgment. Advertising part is not protected against intermediary because we see a lot of advertisements on these intermediary platforms which also violate various laws and various statutes in our country. So it's important that the advertisements as well as the content, how they are curating it, is critical. Coming back to the question that you asked about the rules that got published, I think the biggest achievement, in my opinion, is the synchronization between the Ministry of IT and Technology, as well as Electronics and IT, as well as the Ministry of Information Broadcasting. Because till now, this was a big gap area, especially who should monitor, who should control, and it led to a wild west of the digital media, as I would call it. And this wild west was good for the rampant growth of all these OTT platforms in terms of, and again, you talked about in your opening about the intermediaries, but again, the OTT again itself, from Art Balaji to you name it, Z5, and many other genres which I would not like to name here. But again, this led to a huge arbitrage in the regulation where some websites are banned, but if you put the same content on an OTT platform, it's pretty much allowed because the court said there's no regulation for it. In fact, that was the trigger point where when it went to courts, they said, where's the regulation? And then the government has to do something. An important fact is, again, what the rules say. The rules talk about due diligence by intermediaries, and what impact it will have is that all of us are on different intermediary platforms, but everybody has their own long list of rules which we don't know or we don't want to read, and nobody's really bothered. And that leads to a situation where now the government is saying that at least you have these things in your rules. Tell them, please don't upload content which is copyright violation. Again, very simple things, that nothing really out of the box in some sense. Don't upload content which is this. If you do this, you might be kicked out, or your content might be blocked, etc., which is, I think, a very genuine. Most of the providers already have it. The big part of it is actually signaling. So when you signal to the audience and the users that what is expected as a right behavior, a lot of people who want to create nuisance also get this, and they get excluded. It's this question of exclusion. So the way the government is trying to do is getting more intermediaries to get their house in order. The another point is the significant social media intermediaries and the compliance officer requirement. I think this is very critical, and I think most of the companies would not be liking this, and again, very understandable, because even in our corporate laws and compliances, when all the burdens were put in the new Companies Act on the compliance officer, a lot of companies didn't, or compliance officer didn't like it, and a lot of companies had to put in systems for compliances, and I think it is good for everybody. So for the interim period, it will create some level of extra work, but overall, it will protect the right of the intermediaries, it will protect the right of the users and people at large. The third part is on the code of ethics on the digital media publishers, and I think this is the good part again in this rules very clearly defining the news and the current affairs and the curated online content. It kind of brings in a lot of clarity, especially when in some platforms the boundary line between these two, the news and the current affairs versus online curated content, is very thin. Because if you say Facebook, you have people posting in news video clips, as well as you have other stuff which is not really news. So, but other platforms like OTTs again, and Focus and TV channels focus separately. So there are some places where there might be a gray zone where some of the intermediaries or content providers, publishers, will need to see which side of the line they want to be on. And I think the biggest and the best part is the grievance redressal system mechanism that has been put in, because till now, it's given the fragile nature of what you see on internet. What I see today I see a clip, for example, which shows a child in it, and I raise an issue, I report it. What will the platform do? Platform will say, yes, thank you for reporting, and it will vanish. It will vanish for me. I don't know if it has vanished for everybody else or not. Okay. So that is coming from an intermediary perspective. The situation is actually even more grim when you talk about publishers and publishers of digital media. It's really, really grim. And I think, and Mr. Duggal said, 15 days is too much. Before that, it was like, 5-7 days to acknowledge and 30 days to respond. In fact, myself have raised complaints against news media, and I mean, it is so much delayed that the entire thing is lost. We had an example in Gurgaon, for example, where I live. There was a fight between two groups on a cricket match, and the media was portraying as a Hindu-Muslim riot has happened, something like that. And because everybody wants TRP, everybody wants to sensationalize, and I raised a complaint. First, getting and again the publishing of grievance officer details. You can't get grievance officers of these web. I'm talking of mainstream TV channels. Leave out. They will put a website form which will not work. You don't know who to complain to. All these things. These are real issues on the ground. When things go really bad, it's difficult. And again, in this case also, they have created a very clear mechanism of escalation. 15 days, 15 days, 15 days, 3-level escalation they have given, and which is decent. Again, I still say 15 days is like a year in an online world, so it's not really enough, and they should probably squeeze it down much further. But that is something which I hope this will create an awareness in these media platforms also, that they can't just do something and get away with it in their search for TRPs or commercial gains. So
Right.
I stop here, and again, there are lots and lots of things I can go on, but happy to add on.
Thank you, Nirupam. We are running short of time, but Vaishali, quickly, if you have any couple of points here, or
I do agree with everything that Nirupam just said, and very rightly so. There are so many practical issues when you deal with takedown, especially, and when we have victims of sexual abuse, or when we file cases under POCSO for child sexual abuse. The real relief is takedown. The real relief is not actually the criminal trial. The real relief is not the civil trial for compensation. The actual relief is takedown within 24 hours. And that is a very welcome inclusion in the intermediary guidelines, which has just come in. And again, as he rightly said, finding the grievance officer itself used to take several days as to whom to write to so that you get a response. And so now even having a guideline which says, okay, now you have this one person that you can talk to or write to is a welcome change. Intermediaries obviously are not going to like all this, but it's not for their liking. It is for the benefit of the country.
Right. Thank you, Vaishali. So moving quickly to the safe harbor norms. And again, we'll probably try to quickly respond to this particular observation. Whether the safe harbor norms are adequate. So there is one school of thought possibly is that probably we need more a stringent mechanism to monitor the online platforms. There is other school of thought is that you're curtailing the freedom of speech. And of course, I'm excluding all those the morph picture example or the any sexual content. Of course, those things we of course need to remove it from the platform. But in general, when you say freedom of speech versus hosting that opinion or a view, and whether it can or it should be. So safe harbor norms probably if in the if the government says or the law enforcement agency says that this content is harsh and should be removed, and if it is not removed, if your protection is gone, that's one part. Then of course there are possibly a differential way of looking at obligations. What are significant ones, which is, and what are the typical social media intermediary versus the significant social media intermediary. And so is our norms are adequate? Is there any change required? Does it conflict with anything in the constitution? I think if we can throw some light on this, it would be useful for our participants here. I'll request Abhishek if you share some views on this.
Sure. Thank you so much. And I think this particular question is a kind of a segue into the earlier part of the conversation that was being addressed by Nirupam and to a certain extent by Vaishali. Whereas I completely agree with them that the insertion of 3.2 in the rules, which specifically protects victims of either morphed or other images, and in fact, only a couple of days ago, I did a matter for this actress to enforce her right to be forgotten. It is an interesting case because whereas she gave the consent for recording a particular scene at a given point in time, because it was supposed to be part of a series, and when of course you look at the series, maybe that particular scene is just part of the content that is being broadcast. But when it is taken out of context from a situation where the series was not even finally completed, it was a demonstration scene that was recorded and then finally put on the internet, right? So the Honorable High Court noted that a consent given at some point in time and subsequently withdrawn should not, should entitle the person seeking to enforce that right to be forgotten to a complete remedy. And of course, it is played out very well in 3.2, and that no one can really fight against that particular imposition and saying that it is an onerous obligation. However, the other aspects that perhaps Nirupam had mentioned, and perhaps that's where there is a difference of opinion that I hold, is that I don't think that from a constitutional point of view, there are 2 or 3 problems with the IT rules, and that's where it segues into the safe harbor sort of situation. Taking a couple of steps back, the safe harbor provisions were envisaged under the Digital Millennium Copyright Act of 1998, which is an amendment to the Copyright Act of US. The safe harbor provision for intermediary liability was specifically envisaged to have those entities, the pipes, to not be liable for copyright infringement and subsequently trademark issues, where they themselves were not responsible for putting the content out, and therefore the contributory infringement argument would not be applicable against them in the event that they took certain immediate steps upon being notified that the content that they were carrying on their platforms was infringing. And there's a process set up for that. One of the amendments that was made to the Copyright Act also in 2012 under 52(1)(c), if I'm not mistaken, also addresses that adequately. Now, what we are doing is we are using the concept which is developed for domain of copyright and IP laws in general to a situation where there's defamation coming in, there is aspects of national security coming in, there is traceability and privacy coming in. So we are actually transposing that particular legal principle of non-liability into a different domain where it has not been tested really. And there are a host of constitutional issues that come up. One that you identified very clearly is freedom of speech and expression. If it is the freedom of speech and expression of an individual, in our country at least, that freedom is sacrosanct, but it of course is subject to the limitations of 19.2. Those limitations are 8 in number and clearly identified in that article. Can those set of limitations be stretched, A, to include public interest? Because a couple of decisions that have come out in the recent past have sought to add that 9th element. Second question there is the decency and morality aspect that appears in 19.2. To what extent can that be stretched? I can understand 3.2 perfectly justified. But are you then using that same principle to extend liability to content creators of curated content under the principle of losing intermediary status, even though they are an acknowledged publisher. So either you're an intermediary or you're a publisher. You can't be both. So to that extent, limited extent, Nirupam, I don't agree with you. I don't think the IT intermediary guidelines were envisaged in a proper manner to have been made applicable to content publishers. News publishers ought to have been excluded. Content creators ought to have been excluded. You create a separate law. This is a regulation. It has not even it's not been tested by Parliament. It's an executive order. Yes, it has the sanctity of law till now to sustain that it is set aside. But really speaking, you are mixing up not only constitutional issues, you're mixing up rules of allocation of business 1961, where there's a clear-cut allocation of business of content to MIB, even in the digital domain, and of technical aspects to the Mehta. How are you marrying the two in under one particular executive order? So that's one issue of constitutional challenge. The second aspect is you are providing for a 3-tier grievance redressal mechanism. To the extent that it was a self-regulatory mechanism, it is outside of the scope of the regular principles of separation of powers as established under the Constitution. But once you bring it under statute or a statutory guideline like this one, then you are necessarily subjecting it to a possible challenge on that principle. You have a 3-tier mechanism where the first tier is going to the person, the company itself, the alleged entity which is supposed to take care of the grievance. The second level is going to an industry body. That industry body is supposed to be led by a retired High Court judge or a Supreme Court judge. So you've recognized that while determining whether there or not there is a violation of the IT rules or of any other statute, there needs to be exercise of judicial mind. And then you are putting a third level, which is ultimately going back to the bureaucracy. So the executive, which is responsible for implementing these same very rules and which has notified these rules, is actually sitting in judgment over a judicial determination carried out by a retired Supreme Court or High Court judge. The clear issue of separation of powers violation. So there are a lot of constitutional issues that have come up for debate. And if they have not, they possibly will be coming up for debate. And there are before the Madras High Court, before the Kerala High Court, before the Bombay High Court, and before the Delhi High Court. And perhaps we will see what is the outcome of that. But to come to the aspect of whether or not our standards meet the requirement of what should be there in terms of intermediary safe harbor, I think we need to not only read the IT Act 79, which I think is perfectly in tune with what needs to be done in terms of compliance requirements. I think that the IT rules 2021 need to be dissected and figured out as to what is applicable, what is not. The third aspect which needs to be taken into consideration is the judgment in Shreya Singhal, where Justice Nariman says that I will read down 79 to the extent that merely on a notification to an intermediary that some offensive activity is taking place, they are not required to take it down. It needs a judicial mind or an executive authority with responsibility to have exercised that and given that order for it to be really implemented. Undoubtedly, the one exception certainly can be the 3-2 situation, because that's on the face of it, it's fairly clear as to what are the situations when it can be activated. But otherwise, I think it's a juxtaposition of these 3 things that need to be looked at to perhaps say that if you look at the totality of the legal position, that which is fixed by 79, that which is set out in the IT regulations, and that which has been interpreted by the Honorable Supreme Court, then yes, I think we have a world-class system of implementation of the safe harbor provision.
Okay, thank you, Abhishek. Nirupam, I'll take the liberty probably to skip asking you on any views on this topic, and I'll take it to you the next topic, which is on the compliance officer, because we are running out of time. Companies Act recognized company secretary as compliance officer. Then we had DP, data privacy legislation is expecting to appoint a data protection officer as a DPO. There are, under IT rules, we have probably a nodal officer required to be appointed. now we have a compliance officer for the purpose of monitoring under this rules. Of course, more work for the legal fraternity, so good for all of us. But one question is, do we need in one company, how many people are going to be governing and looking at things? So I'm looking at from that perspective. And of course, as far as Twitter or WhatsApp issue is concerned, it all flared up with the issue of appointment of compliance officer, specifically in the context of Twitter. What do you think is the right approach for the role of compliance officer, and whether multiple legislation should have their own officers to be designated, and then they do their respective, streams of the role? Any thoughts, maybe, Nirupam?
Sure, and I will come back, Abhishek. We'll talk that offline given the time frame. But coming to the question, Bharat, so the compliance officer is definitely wearing a crown of thorns, no doubt about that. And the liability in many cases, especially as I said, the wild west of social media, is onerous because they never thought that this would happen, and they probably thought they're always above the law, and the governments can't do it. I mean, this happened with the Senate hearings, Facebook, Google, everybody you name it, that has happened in US, and they have like walked through it without even blinking an eye, thinking twice about what's going to happen. Now the situation, obviously, in a much smaller country, and I'm saying comparatively smaller in the sense the way these social media giants treat India as compared to US. So in a much smaller country, they thought probably, this will be a cakewalk. If US couldn't do anything, what would these guys do for us? And probably the realization came in later that this is going to be the future biggest market for them, and they can't really, mess up with this. And the regulation is coming straight and hard, and I think the government has been pretty relaxed, going to this question. Now, coming to the real aspects of the job and the multiple compliance officers, I think technology is going to come to the rescue. And even I think a lot of it is probably some wrong lawyers advising them wrongly, I would say. Simple things like traceability does not need encryption breakout. So you can have encryption and you can have traceability both together. I mean, otherwise, how would blockchain work? Blockchain is completely encrypted, and still you can trace each transaction to the origin. So the whole logic of, this is a PR media stunt of the social media giants, as I would call it. Again, some of my good friends there, but just to put the perspective from a technology perspective here. So a lot of things are possible, and again, technology can solve this. Even in the company law, the corporate laws, what has happened? The technology has come up. Now every company has compliance suite softwares, making sure whenever transaction happens, there's a related party transaction, then it will trigger out a pop-up saying this is a related party, please follow these compliances, or this is something else, please follow that compliance. So same thing is going to happen, and again, in fact, the rules itself says please use technology, please have tools to screen that if your content includes child, if your content is like this, please filter it out. If we have already given instruction to block one type of content, use tools to look out for other contents which are of similar type and block them out. So there is a relatively I would not call it simple solution, but existing solution, I would say that way, that the compliance officers will need, and obviously in the short term they will need probably a huge amount of man force to implement this, because this they thought probably they will walk over it, and that's not looking like going to happen, especially for intermediaries. On the digital media side, they probably have got some relaxation with the Bombay High Court interim stay. I will not go there because you asked me not to go there. But the whole point is that this is going to be a big, obviously, revenue booster for lawyers as well as IT firms who are going to analyze this digital media and content and build tools for servicing the compliance officer.
Okay, thank you, Nirupam. I think we are way out of time, and that's why Prajakta Madam is here to warn us. I don't know, Prajakta, if we have time for questions or.
I think if there are really imperative
There is
questions
one
that you may
question also.
consider crucial to take, I think we can take quickly one question before we wrap up and finish, the entire session. We can sum it up.
I
Maybe
think
one
I
question.
saw.
Yeah, I have just one question. Thanks, Prajakta, and it was a wonderful panel. Thanks, Bharat. So my first question was on this under new rule. Maybe Pavan can throw some light on this. So under this new rule, the compliance officer can have multiple roles. Like, see, we already have a compliance officer who's anyway handling the ABC, AML, and grievance. So can we appoint the same person as a compliance officer under this new act as well?
But the law is silent there. It only says you need to have a compliance officer. It does not say that he has to be completely divorced from his other responsibilities. But it's advisable, given the kind of a huge vector of surface area of potential legal exposure, that if you have a dedicated compliance officer vis-a-vis the IT Act and the IT rules, because if you're putting so much of compliances on one person's head and something goes amiss, then the entire company, the compliance officer and the top management are going to be exposed to legal consequences. Similarly, a lot of companies have this mistaken notion that you can all put the role of a compliance officer, a nodal officer, and a resident grievance officer in one and the same person. I think the law does not have any such envisagation of a kind of a image. It's very clear. These are three separate elements in three separate officers. Yes, it means more costs for the company, but I think it's much more better, because in case if you're going to cut our costs and put all the responsibility elements into one particular basket, then the potentiality is that you're putting all your eggs in one basket. One egg breaks, the entire basket could potentially be exposed.
So one more follow-up question is, like with startup companies who have a team of just 20 or 30 people and who are coming up with this messaging and all that. So do we have any relaxation for at least such startup companies? No?
Unfortunately, the law is not at all drafted keeping in mind ground realities. They thought, they are only talking about big social media companies when they came up with these rules. They forgot the term, how the term intermediary was defined under 21W. So if every small company, forget about 20 or 30 people company, my local Kirana wala shop guy, just having 2 computers and 4 people, he also becomes an intermediary because he's saving my data. That being so, they've not really given a caveat, a kind of an exit route for these small companies, but very quickly they will have to start giving that. Otherwise, the entire country is together in its disobedience, in its non-compliance with the IT rules. So does that mean that you will go ahead and prosecute everybody? That's not going to be possible. So somewhere down the line, there'll have to be more sanity in terms of how we can make this more topical, more relevant, and not unnecessarily burden small and middle-sized companies with these kinds of consequences, which are clearly not desirable.
Thank you so much, sir, to know your thoughts on this, which is so positive, and I'm sure you would help us to get that exemption for at least startup companies. Thank you.